Hi and welcome. My name is Nathan Cieszynski. I'm the Program Manager for Fair Housing Council of Riverside County. Today we are going to be speaking about AB 3088, also known as the COVID-19 Tenant Relief Act of 2020. Joining me today is Karl Wallen, a staff attorney with Inland County Legal Services. We're going to be speaking today regarding the requirements for AB 3088 and how that applies to the tenants in the state of California and what protections that will offer to them. At this time, I would like to welcome Karl Wallen. Karl, good afternoon.
Thanks for having me. Happy to be here.
Karl, before we begin, could you tell me a little bit about Inland County Legal Services and the services that you provide to the residents of the Inland Empire?
So ICLS, or Inland Counties Legal Services, provides services to the indigent community, those who might not otherwise be able to afford an attorney. We're here for qualified individuals to provide counsel and advice, occasionally extended services such as preparation of legal documents or even representation in court. There's a variety of different types of law that we can assist with. Unfortunately, we can't assist with all of them, but to give you an idea of some of our services, we provide extensive housing work, family law work, immigration, bankruptcy, tax, consumer, and even systemic impact major cases that affect numerous litigants.
At the end of August and the first part of September, I believe actually September 1st, Governor Gavin Newsom signed into law AB 3088. Could you tell me what initial impact and what benefits the Tenant Relief Act provided to the tenants of California?
It was sort of done, I think almost quite literally at midnight. It was the final hour, essentially, for the legislature and the governor to get together and pass something, because Emergency Rule 1, the prior rule, which had essentially been sort of carrying the day between that March of 2020 period and the September 1st, 2020 period, Emergency Rule 1 had effectively stopped most, we're probably talking between 95 and 99% of evictions in the state on its own. Now the judiciary, it was a judiciary rule, it was a judicial council rule. The judicial council was no longer comfortable with that order being in existence for as long as it was, and they wanted the legislature to do something about it. So they essentially forced the legislature's hand and effected an end to Emergency Rule 1 in September. The governor, as well as the legislature, got together, worked real hard, put together AB 3088 as the answer. That has been in effect since September. It is not quite as protective as the old Emergency Rule 1. Evictions can and indeed are happening, and more of them are going to begin happening on October 5th. But it was perhaps a much better solution than just letting things go their course. There's numerous protections in AB 3088 that are probably going to help a lot of people. So it was real pins and needles there for a little while as to what exactly was going to happen. Would the legislature be able to set aside their differences, especially landlord lobbies, resident lobbies, and get something together before the timer ran out? And they did it. And now there's some pretty good protections. AB 3088, the writers have indicated that it is a short-term solution, so we could perhaps see something else on the horizon get made, but for now, that's what we have.
I know that you mentioned that there are evictions happening and that will continue to happen, and I'm definitely going to want to get into that a little bit more in a few minutes. But first, could you tell me what were the immediate protections that the tenants received from AB 8033?
There's actually quite a few things that AB 3088 did. I'll certainly go into, at least preliminarily, the major ones, the ones that most people are going to want to hear about. Perhaps the most foremost one is that it gave considerable protections to tenants who are not going to be able to pay their rent or who haven't been able to pay their rent since March of this year. AB 3088 has essentially stated that you can send a declaration of inability to pay your rent to your landlord. And if you were to do this, it would prevent eviction for any back owed rent during the period of March of 2020 to September of 2020. And you'd only need to submit a single declaration to get this benefit. And you can never be evicted on the basis of owing that rent if you do this. Of course, subject to the declaration being truthful, signed under penalty of perjury, etc. In addition, not only does it protect for non-payment for months between March and September, it also protects beyond that as well. For months between September of 2020 and leading up to January, including the entire month of January, tenants can continue to submit this declaration every single month if they are unable to pay their rent. And this will protect them from having to pay all but 25% of the rent due. And that rent must be paid before the end of January. And if that 25% is paid, if all of the declarations are timely, properly submitted, and are truthful under penalty of perjury, that would prevent eviction for all but the 25% that is due in owing. They do still have to pay that. If they fail to pay that, they can be evicted beginning in February. That's probably the most major change. They're obviously
So let me do. Right. Let me go backwards just a little bit to make sure that everybody is clear on this. For
Sure.
those that weren't able to pay their rent beginning in March, they only had to submit one single affidavit up to September, and then after
Correct.
September, they would be required to submit an affidavit a month.
Every single
Is that
month.
correct?
It's
Okay.
absolutely correct, and I'm happy you point out that distinction. It's a very important distinction because the last thing a tenant really wants to do right now is submit one for September and think they're covered until February, only to find out that they need to submit one of these every single month. It's a huge
Right.
distinction from the March period.
And that 25% only goes into effect as of September forward, correct?
Correct.
It's not backdated to March.
Correct.
Okay.
Another
So,
important distinction.
When you talked about evictions that are going on and will continue to go on, because I know before this was passed, it was almost a blanket statement unless it was a health or safety issue. There were no evictions, period. And I realize that is what type of reasons can somebody be evicted for right now under the exception of SB 3088?
Gotcha. You're correct to point out that under the old emergency rule 1 that expired, the only evictions that were really happening were ones that were on an emergency basis, typically threatened the health and safety of nearby residents, etc. Now there are considerably more reasons under which a landlord can evict, and they can do so now. There's no protection from them doing that right this moment, as long as they have cause. Now, the cause can be found by hearkening back to an older code that AB 3088 refers to, and that's AB 1482. That code gives us the just cause bases for evictions now. There are two major types. There's at fault and there's no fault just cause. They're both just cause. Either one is sufficient to evict right this moment, with no barrier for the landlord to submit the notice, as long as the notice is proper, to file the eviction on that basis. To give you an idea of what at fault just cause would be, there's several, but they tend to involve a failing of the tenant. That could be failure to abide by the terms of the contract, the rental agreement. It could be nuisance activity, a threat to health and safety, significant crime, perhaps sale of drugs or narcotics, something like that, that resulted in a arrest conviction. Those would all be for-cause eviction types that would be allowed under AB 3088 and AB 1482. Now, the other type is surprising to some. The other type is no fault just cause. It's still just cause, but it oftentimes involves nothing to do with the tenant. The tenant could in fact be the perfect tenant and still find themselves being evicted under no fault just cause. There are several examples of no fault just cause. The most prominent ones that you are likely to see are the landlord's desire to remove the rental property from the real estate market, so essentially just no longer desiring to rent, perhaps using it as a residence instead, selling the home to a new landlord who essentially wants to do the same thing, to reside in it as his principal residence. That would be a major exception. Additional no fault just cause would be if, for instance, red tag, if the government were to order the vacancy of the unit. So none of these things necessarily entail the tenant failing to do something or failing to undertake an act that they were supposed to do, but they could still be evicted. Those are the cause bases that exist at this moment.
Coming at it from a fair housing standpoint, as you are well aware, Fair Housing Council Riverside County deals primarily with the low to moderate income residents of Riverside County. We deal with those individuals who are more likely to be susceptible to discriminatory treatment under normal circumstances. With the passage of AB 3088, it seems to me that there is a possibility of these exceptions and these loopholes for evictions. And again, I understand that they're not technically loopholes because they do follow the guidelines of the laws. But I have a feeling that there's that possibility that there's going to be landlords who say, you know what, I'm sorry, you can't pay your rent. And I know technically I cannot evict you because you can't pay your rent because you're protected under AB 3088. However, I'm going to find some other reason to go ahead and evict you. And since there are those other options that are available to them, what remedies would you say are available to a tenant who feels that their fair housing rights are being violated and that they are being unfairly evicted simply because they can't pay their rent, but another excuse is being fabricated or used?
This has definitely been an anticipated thing. Not only has it been anticipated by organizations like ours, it's also seemingly been anticipated by the legislature themselves, because they specifically addressed this and created a new remedy and sort of, for lack of a better term, beefed up old remedies in dealing with this and combating this. The way that it's basically being described now, what you have hinted at, the fancy name for it that's being tossed around right now is pretextual evictions. It's essentially, we all know, or at least we think we do, the real reason for the eviction, the lack of payment, but some other reason is being created to skirt around that protection under AB 3088. That would be a classic example of the pretextual eviction. In this case, there has been additional laws created, and again, a shoring up, so to speak, of the old remedies. Retaliation has always existed and has always been a defense to unlawful detainer, but now the civil code in which you find retaliation, Civil Code 1942.5, also specifically mentions this exact behavior. And if a tenant can prove that this behavior exists, not only can they use this as a potential defense to the eviction, they could use this as a means to seek damages, to sue. And those damages under this retaliation theory have been increased under that code. That would be the new way to go about seeking recovery in this example. But of course, all of the old strategies will still work as well. None of those have been shelved. If the client can do so, they could consider doing a reasonable accommodation letter if they perhaps suffer some kind of disability. In addition, if they feel they're being discriminated against, the discrimination codes and unlawful detainer defenses and causes of action in civil law, those all still exist. Those didn't go anywhere. So of course, I would encourage the client to navigate those avenues as well.
So let's take a moment here and shift gears just a little bit. We've talked about the tenants. So let's talk about the property owners. Let's talk about the property managers. What are their requirements under this particular bill? Primarily, are they required to track down a tenant to obtain that affidavit? Are they required to verify the information on there? I know that I'm asking a lot of questions, but I've literally received calls from property managers that have flat out come out and told me, I don't believe that this person has been affected by COVID-19, and I don't believe that I should allow them to fill out this affidavit. What are their requirements? What should a landlord, a property manager, or a property owner know about this particular bill?
Most cases, the affidavits, the declarations that we've been discussing are self-certifying. The tenant says that they are suffering these problems, and that is the presumption, is that they indeed are. There are some very minor exceptions, and those would relate to high-income tenants, tenants that the landlord knows and has proof of, because they have documentation already to that effect, show that the tenant makes over 130% of the average median income. So those are going to be some pretty high earners. If a high earning tenant were to try and do this declaration, the landlord could essentially demand proof at that point in time. That is also spelled out in 3088, that procedure under which the landlord can do that. I would recommend that the landlord not go off hunches. They need to have something definitive that shows that the tenant makes that kind of money in their records. And if they don't, that is probably not going to work. That is the only instance under which the tenant's declaration is not necessarily self-certifying and subject to additional proof and challenge under 3088.
So on a personal note, that is one that I find a little bit interesting. And I think one of the reasons I do is because as we look at the individuals who've been impacted by COVID-19, those individuals that perhaps had the verifiable income in January that would exclude them from the protections of this particular bill, today they may not have that income. And just because they have it documented in the past does not mean that they have it now. There have been hours that have been cut. There have been jobs that have been lost. There's the increase in childcare and somebody having to stay home and take care of those children. So to me, thinking of it more from a logical standpoint, it seems to me that it would make more sense for the property manager to err more on the side of caution, given the fact that just because they have proof of previous income does not necessarily mean that there is that same income right now.
Yeah, there's been, as we all know, there's been a lot of business closure. There's definitely been job loss, and even partial job loss, reduction in hours, reduction in wages, any number of which could reduce the tenant that was before making greater than 130% of the average median to now making less. And if they could prove that, they would still be allowed to submit the declaration, and it would still work just as effectively as it would for anybody else. So yes, that's a valid concern.
So Karl, as you and I both know, when it comes to situations that are affecting individuals, there is a tendency to try and avoid the problem. And I am speaking currently right now about tenants. You know, if they don't have to take the phone call from the credit card company, if they don't have to take the phone call from the car payment company, if they can avoid the landlord, there's this idea that it's going to go away. And my question on this, it's more of a question, maybe a clarification. If a landlord has not received notification from a tenant regarding, or they have not received the affidavit, as we're talking about, and to clarify that, one of the things that I recall reading, and of course I'm not a lawyer, but I did try to read the bill and understand it. I understood that there was a particular window of time that the affidavit must be submitted for it to be acceptable. But then in the language of it, it appeared that there was also possibly an exception or an accommodation that needed to possibly be made. So if you have a tenant who hasn't met that window, who has avoided that landlord, how does this affect the situation?
Absolutely. So the affidavit itself would have to be submitted within the new 15-day notice window if a tenant wants the best chance of success for that declaration to work. That would be the soft deadline to submit it. I would go out of my way to recommend, if anybody were to submit that declaration, that they do so within that window. You certainly don't want to wait because it becomes much more difficult for the court to approve that declaration working after that window has expired. But yes, so in addition to what we've already talked about, AB 3088 now requires a 15 court day notice for lack of payment of rent. Those that may be familiar with the old laws, it was always a 3-day notice to pay rent or quit, and it wasn't always 3 court days. 15 court days excludes holidays and weekends in their calculation. So that 15 court days very quickly becomes a bit over 3 weeks for the client to, 1, pay the rent, or 2, submit this new declaration. Failure to submit the declaration within those 15 days could give grounds for the landlord to start the eviction. Now, you'll recall that I mentioned the 15-day timer was a soft deadline. The tenant could theoretically still submit the declaration within the time to answer the eviction. Doing so, however, would force the court to examine whether or not the tenant whether or not essentially that declaration is going to work. And their analysis is going to be found under Code of Civil Procedure 473. They're going to look and see whether or not the tenant's surprise or there was actual surprise there, excusable neglect, lack of notice in time to actually serve it. They're going to look for those factors. And it's a lot more grueling analysis than it sounds. It's not easy analysis for the tenant to meet, which is why I highly encourage them to submit it during that soft deadline 15 court day timeline from the day in which they receive the notice, as opposed to waiting, because it's very likely not going to work unless they have a really good reason for why they didn't submit it in time.
I'd like to ask another question regarding the bill and the protections, and so that we have a full understanding of how this works. So hypothetically, I complete my affidavit, I submit it to my landlord. Am I required at that time to pay that 25% of my rent then? And if I'm not able to pay that 25% when I submit the affidavit, does it invalidate the affidavit and make me ineligible for the protections under AB 3088?
Great question. The short answer, I'll obviously expound and go into the longer one. The short answer to both your questions is no and no. You have until the end of January to submit that 25%, and it can be done in lump sum. Again, I wouldn't recommend this. I would recommend the tenant to timely pay their 25% if they can, because while it is perhaps short-term pleasantry to withhold, that deadline, once it looms, it may be hard to actually tender that 25% for 3-4 months at one time. It can be difficult to pay that if you're not on top of it every single month. So while you can wait, you shouldn't necessarily do so. But But no, it does not invalidate the notice. Let's assume absolute worst case scenario here where the tenant submits the declaration timely within the 15 court days, but they never pay a dime. They pay nothing. They fail to pay the 25% within the time limit. What happens? Well, they can't be evicted for that entire covered period until February hits. But once February hits, all those protections lift. The landlord is justified at this time under current law in filing an unlawful detainer and seeking eviction from the tenant on that basis.
So just to clarify, what we're saying is that that tenant is responsible for paying the 25% of their rent. And then they are also responsible for making sure that they pay that 25% throughout the period until this particular protection is lifted. However, that does not relieve the tenant of their obligation to pay all of that rent. Is that correct?
That's a perfectly stated distinction. So let's explain what happens. Where does all that money go? Does it just disappear? Not quite. So all of that money can be gone after by the landlord, but not an eviction. If the declarations are properly done, payment is timely submitted on that 25%, the landlord may never go after that money in eviction. Now, those are key words, in eviction. The landlord still can go after all of that money in small claims. The small claims limit in going after that money has been erased. So there's now no longer a $10,000 threshold. The landlord can go after the entire sum in small claims. That entire amount is converted to civil debt that the landlord can go after, and some will. But again, let's play advocate here for a moment and assume worst case scenario that that your tenant, the landlord, does indeed go after you for this when they're allowed to, which starts in March of 2021, and you get a judgment against you. You do not get evicted. You just have a monetary judgment against you that the landlord can try and enforce if you would like, but that can be very difficult.
So from a fair housing advocate standpoint, not a legal one, obviously, but from a fair housing standpoint, the way that I kind of see this and understand it is that AB 3088 has the potential of stopping or slowing the avalanche of evictions that we had anticipated. Would you agree with that assessment?
It has slowed the avalanche. The avalanche is still likely to occur, perhaps at a later date. But in the meantime, I hope we're not met with a scary surprise of how many evictions are going to be able to go through AB 3088. While the tenant does have the opportunity to submit this declaration, I fear how many tenants there are out there that might not know that they have the ability to submit this declaration, that may fail to timely submit this declaration. And in so doing, they do not get the benefits thereof, and they can get evicted. Non-payment evictions can resume again October 5th. All other types are allowed to happen right this very moment, but non-payment can start again on October 5th. So look out for that time. Hopefully the news can be spread to enough tenants to stop that avalanche that you hinted about. But if the knowledge isn't there, the avalanche might happen, and it might happen now. It might happen sooner than we thought. And in the meantime, this is still has potential to cause that avalanche once the protections are essentially lifted in February. Then we could just see it then if the legislature doesn't enact new protections.
So how does AB 3088 differ from the CDC moratorium? I've done a little bit of reading, and I have to say I was a little surprised personally that a moratorium was issued by the CDC. I would have thought that something like that would have needed to come as either an act of Congress or the Senate or from a state level. So how does it differ? And is there any legal authority on the CDC moratorium?
There is a alleged federal basis for the CDC to enact the moratorium that they did. Essentially, it's made pursuant to a health and public safety standard and guideline. Thus, that's the avenue that they're going off of. Obviously, this is already being contested in court, and the true answer to the question that you just asked me will soon be revealed through appellate work at the higher court levels, where they decide, does the CDC in fact have a federal basis for enacting this? For now, the CDC has argued that they do in fact have a strong claim to do so, and they might. But the ultimate decision will be made at the higher level courts, and almost right after this thing was made, it was already getting challenged. So I can't predict exactly when we'll hear a definitive answer to if they have the authority to do this or not, but look out for that. Look out for the decisions in those cases that will truly give us the answer of whether or not they have the authority to make it. You had asked what distinctions there are between AB3088 and the CDC moratorium. Now, some of this is going to be my own editorial opinion, so take it for what it's worth. Many of the things that I'm going to tell you now are going to find themselves being litigated both at our local courts and at the higher level courts on appeal. This whole interplay between the two statutes, between AB3088 and CDC moratorium, how they work together, there's no guideline. It's all gray. It's all legal gray matter. And it's going to need to be sorted out at a higher level. So what you're going to hear me say is my educated guess, my educated opinion as a practicing attorney in this field. It could be wrong. But with that said, here's my spin. The CDC moratorium is, in my opinion, more wide-ranging in protection than AB 3088. The CDC moratorium stops all but 5 limited bases for eviction. You'll recall that I mentioned AB 3088 allows cause evictions, even no-fault cause evictions. The CDC moratorium does not. And it is in that way and in several other ways more protective and more wide-ranging than AB 3088 in its protection. Now, the CDC moratorium, just like the AB 38 statute, requires a declaration, but this one only needs to be submitted once. It's very similar. The tenant basically affirms that they can't afford to pay the rent based on some COVID-19 related reason. Doesn't mean that they suffered from COVID-19. It doesn't mean that they got COVID-19. It might mean that their income was affected, or that they took care of a family member, or increased expense as a result of COVID-19. And a lot of people can say this one, such as childcare. Schools are closed. With schools being closed, a lot of people are having to pay far more childcare than they've ever had to pay. And that would certainly be a reason, both under AB 3088 to do the declaration, as well as the CDC moratorium. But nonetheless, in my legal opinion, the CDC one is more protective. Now, I'm being a little cheeky when I use those words more protective, because the CDC moratorium itself says that it applies when it is more protective than a local or state law or ordinance. So in my opinion, it applies because it is more protective than AB 3088 and is very much in effect in the state of California. Now, whether or not California courts or indeed federal courts agree with me is another story, and we'll find that out in the future.
Under the CDC moratorium, how exactly does that work? Is it, here's my affidavit and everything will be taken care of on the back end, or am I also required to pay the 25% rent during that period? How exactly do the two bills differ?
Great question. Happy you asked. So it's a double-sided sword here. There is no requirement to pay anything once you've submitted the declaration. However, the protection lasts only until the end of the year, and there's no further protection beyond that. So if you were indeed to fail to pay during this period of time, and you were not able to work something out with your landlord, and you were relying on the CDC as a defense after this year, it's not going to work. It's not going to do a thing for you. So it's only good between
Right.
now and the end of the year. And as soon as that ends, if you failed to pay even a small amount, let's say several $100s, you are arguably in breach of your contract. You can arguably be evicted. Um, it, and the CDC moratorium would not be of any use to you after that time. Keep in mind, this is subject to change. These laws change all the time ever since March. It's common to see updates every month, every couple of months. So this commentary is true as of now. But if you were replaying this, no longer at September 29th, but instead on November 29th, the analysis might be completely different. So stay updated.
I completely understand and agree with what you're saying there. I know that prior to the passage of AB 3088, the Fair Housing Council of Riverside County was trying to work with and understand the different guidelines. We had the state moratorium, we had the moratorium from the Superior Court, we had the cities and the counties, and it was very difficult trying to make sure that we were providing at all times the most accurate information that we could. Here at Fair Housing County and Riverside County, that's exactly what we do, is we try to keep the community informed of their rights, both their civil and their fair housing rights. So I'm very happy that we have AB 3088 because it does seem to make it a little bit more understandable. And with that, I'm also very grateful that you were able to take the time out today to spend with us and explain it. I know there's a lot more that goes into AB 3088 than what we've had time to discuss, but I feel that we've managed to hit the most pertinent pieces of it as it pertains to the tenants. So again, we thank you very much for taking the time to spend with us today. So before we close, I'd like to ask you, what advice would you like to give the residents of Riverside County? As we both know, there's going to be those individuals who will watch this. There'll be those individuals who will go online and try and research it and understand it. And it's not always easy to understand. And so if you could give one piece of advice to the residents of Riverside County, what advice would that be?
If I had to condense it down into some fine points, I would say this. If you can continue to afford your obligations, you can continue to cover your own necessities, and you don't need this protection, you might not want to take it. You might want to continue paying your rent timely and in full to avoid any potential complications down the road. That will always tend to be the safest course of action if you can do it. So if you need these protections, use them. Stay updated. Know your rights. Continue reaching out to organizations like Fair Housing, like Inland County's Legal Services. Ask questions, ask about your rights, and know them. Because if you don't know them, you're going to lose them. If you didn't know about this declaration and you didn't submit it, you would have lost all the protections that we talked about today. So you need to stay up to date. Because if you don't, that's not going to be a defense later down the road. When you're in front of that judge, you can't tell them, I don't know, I didn't know. It's not going to work. You have to know. Stay updated. So pay if you can. If you can't, know your rights and make sure you follow it. Dot your I's, cross your T's, submit your declarations, pay what you need to pay. Pay that 25%. Pay it timely. Pay it as fast as you can. That way you don't have to have that scary lump sum at the end. And if you find yourself needing to argue on your benefit, on your behalf, don't forget the CDC moratorium. Argue that that applies. It certainly can't hurt. Can't hurt having more defenses. Argue that AB 3088 applies, and protect yourself.
So that's really great advice. The one thing that I would like to add on behalf of Fair Housing Council of Riverside County is to communicate with your landlord. The problem is not going to go away. It's very important to communicate with your landlord, complete those affidavits, because what you don't want to happen is at the end of the COVID-19 pandemic, when all the moratoriums are lifted, to find that you have lost out on the protections and opportunities that Karl has been very gracious to go over with us and explain. Karl, if somebody needed to get a hold of Inland County Legal Services, how would they go about doing that?
You can contact us via our toll-free number. We don't cost anything. If we're able to accept you for services, we don't charge you anything. Our number is 888-245-4257. And again, we're Inland County's Legal Services.
So this afternoon, we've had the opportunity to dive deeper into AB 3088. And I hope that it has provided you with a better understanding of what your protections are under the bill, and also an understanding of how your fair housing rights could possibly be violated under this exact bill, simply because a landlord may not necessarily be willing to work with you in regards to the affidavits, and knowing that they cannot evict for non-payment right now, they may look for other reasons. So we invite you to be on the lookout, pay attention, and if you feel that your rights are being discriminated against, if you feel that you are being unjustly evicted, please give our office a call. That number will appear at the bottom of the screen. Karl, we would like to thank you once again for taking this time to fully educate us, and I hope all of our listeners have gained a much better understanding of what this bill actually does and the protections that are available. And I would like to wish everybody a wonderful day and remind you, your fair housing rights are important, and Fair Housing Council of Riverside County is here to help you to understand your rights and to really enforce them. Fair housing rights can only be enforced when people stand up and say, I'm being discriminated against. And we invite you to contact our offices if you find yourself facing any of those issues. So again, thank you and have a great day.